Magoo.
All right. We're ready for preliminary examination, or at least to deal with his motions. What are we doing?
Yeah, would the court be so kind as to make the self-representation inquiry? And
yes.
Perhaps we could look at the motion first.
Mr. Magoo, you are here before the court. You're set today for a preliminary examination. You're here before the court on the charge of resisting and obstructing a police officer. That's a felony, punishable by up to 2 years incarceration, $2,000 fine plus court costs. You appear here unrepresented as you have in the past, and the court has given you the admonishment regarding self-representation. You're going to represent yourself?
Yes, Your Honor.
Okay, what are we doing?
To begin, I'd like to just announce a brief summary of the incident that happened.
Pardon?
The incident on October 11th, the reason why I'm here. I would just like to announce a brief summary of what happened.
And that's going to get us where?
Well, I did file a motion a couple weeks ago for discovery. I do have a copy of each.
Yeah, no, I saw it. Did you get the discovery?
I did not, but I don't think I properly served it on the prosecutor, so I'm here to do that today. I did serve it with the courts. I did file with the courts.
Oh, no, I saw it. So what do you want me to do with your case today?
Well, I a few things. I want my bond conditions lifted. I want a discovery. I don't know exactly what the procedures here is. You know that wrongly.
Yeah, I know, because as you're talking and as everything went through, I could tell you didn't know.
Yeah, sorry. But I'm trying my best to do things right. But I just
okay, you haven't started out well.
Sorry. I'm here because I'm told to be here today, Your Honor. That's all.
I know.
So what I want to do
kind of goes out in my name. So yes, I know why you're here. Let me ask you this. You want to represent yourself in this?
Yes, Your Honor.
You don't want help?
No.
Okay. So I'm going to do this. I'm going to apprise you, if you wish to represent yourself, you're constitutionally entitled to do that. I will apprise you that you are before the court on the charge of resisting and obstructing a police officer. You understand that charge?
I do.
All right. That is a felony or a high court misdemeanor. It is punishable by up to 2 years incarceration, a $2,000 fine plus court costs. You understand that?
I do.
All right. You also understand, sir, that there can be great peril in representing yourself.
I understand.
You understand also that at this proceeding and any other further proceeding, that the court is going to hold you to the same standard the court would hold anybody else to. And the court will not play favorites. The court will not help you out. The court will not be assisting you. You understand that, sir?
I do.
All right. If at any time you wish to be represented by an attorney, and if you cannot afford to hire an attorney, but if you wish to be represented by an attorney, the court will afford you that opportunity to be represented. You understand that?
That process is throughout the whole discovery and trial.
Pardon?
I can be assisted with if I can.
If you request an attorney represent you in this matter, that the court will at that point, if you cannot afford to hire one, the court will make sure that you have one. If you wish to get another.
At this point, the defendant chooses to represent himself. The judge explains the felony charge of resisting and obstructing, which carries up to 2 years in prison, and warns him of the serious risks of self-representation.
A request for suppression of this evidence until full
suppression of what evidence?
Of body cams, squad footage.
On what basis would you be doing that?
Miranda versus Arizona.
Which says what?
That I was not read my rights prior to being detained, and because of that, any violations that I could have possibly said that could impede my case.
That's your basis for the suppression of body cam?
that I have the right to be read my Miranda rights and know that anything that I say can be used against me. I was not
So
notified
that's your basis
to suppress
the body cam.
I'm not trying to suppress it from the court to see. I don't want it in the public domain. I don't want it, anything that happened. I was on the scene. The police were on the scene for 2 minutes. They were dispatched there over a fight.
I don't know what. Okay. You're going to have to put more in writing for me to even understand that, because as it stands here right now, based upon what you told me, I'm going to deny your motion.
Deny my motion to suppress under Miranda.
As you're calling it, your motion's denied.
Okay. Maybe I'll formulate my request a little more precise to my specific conditions, but I also am requesting that there's full discovery in this process.
Okay. Have you sent a request to the prosecutor's office for discovery?
I have not. Nope.
Have you asked them, how do I get discovery?
No, I will be doing that.
Do you ask anybody how to get discovery?
I asked a couple of the clerks, but they can't, give too much legal advice. So I'm trying to take as much responsibility for this as I can.
Okay. Well, I'm going to, at this point, deny that motion because there hasn't even been a request for discovery. If you don't get something, then you bring a motion for discovery.
Okay.
Next thing you want to do.
Discontinue all hearings until there's substantial evidence on file.
Okay, that doesn't happen that way. I don't know what discontinue all hearings mean.
I don't know either, Your Honor. I'm just representing myself over here.
This is going to be a long process if you just are throwing stuff out there.
I tried to prepare my best for this. I'm really
okay. This was your best. Then you may want to consider getting an attorney, but I'm going to let you go because you have a constitutional right to do it. But this is going to be a long, arduous process if we're going to go at this rate.
What does the prosecution expect next in this case?
Pardon? What do you mean?
You're asking me for what I want out of this case and what I expect.
I'm asking you, what do you want to do today?
I want to go home and have all charges lifted.
That's not going to happen.
Okay, so
I mean,
what do I got to do?
Going home is an option, but the charges aren't going anywhere.
I understand, and that's the end goal of where I want to be one day, acquitted of all charges.
Your Honor, I don't mean to interrupt, but I am from the public defender's office. I'd be happy if the court wanted to pass to talk with this gentleman.
He says he wants to represent himself, and if he wants to talk to you, then yeah, I mean, I know, Mr. Getty, and I appreciate it, but what do you want to do, sir?
I'm not sure what you're asking me. What are my options, sir? Your Honor?
The court will not help you out. The court will not be assisting you. You understand that, sir?
I do.
All right. All right.
What do I want to do?
Here's what I'm going to do. I'm going to take a break because I have to have something happen before noon. I will call the Spanish case up afterwards. I will also then call the one plea, maybe, that we have, and then I'll recall your case in the next block.
Okay.
And then maybe between the time I leave this bench and come back, you'll figure out exactly what you want to do.
Yeah, I'll
maybe how to do it.
I'll do that.
Or maybe if you want an attorney to represent you to help you through this process, because otherwise this thing could go go south for you.
Yeah, I
and
understand.
not be good. But I'll let you think about that. That's your call.
All right.
Court's in recess.
All right.
Court recalls case People versus Daniel Magoo.
Pass along to the people.
In Your Honor.
State your name.
Daniel Magoo.
All right.
Your Honor, when the court passed this case and left the bench, the defendant did hand me a copy of his motion. I took the recess of the court to file a response. I hand delivered it to the defendant, as well as handing a copy to the court. If I may just respond to the record.
Yes.
Thank you. So this motion was sort of put in 3 different sections, for lack of a better term, and they seem to all, like 1 through 11 in each section seems to be the same item. So I only responded to the middle section, which were the motions and requests. The first motion was to compel the testimony of officers at a deposition. I'm asking the court to deny that. As the court is well aware, depositions are not appropriate in criminal court. Does the court want me to go through each one and then make a ruling on all, or do you want to do one at a time?
Let's do one at a time.
Okay.
All right. You got any response to the people's response?
Not for that, Your Honor.
No, motion denied.
Thank you. The second request is request for discovery, where the defendant appears to be requesting that we produce different discovery items, as well as there's a sentence here that says the defendant possesses exculpatory video footage. Request an opportunity to submit it for review. If he wants to give us something, that's fine, but I just think he should go through the normal discovery process, and I'm not saying the court not order what he's requesting in number 2, because it doesn't appear that there's been any request filed for discovery that hasn't been fulfilled or completed at all.
Well, here's what I'm going to do, at least at this point, is I'm going to deny the motion, that portion of the motion also. When he submits his request for discovery, then I'm going to deny that one specifically without prejudice. That way he can raise whatever issue he may have.
I agree completely. Thank you so much. Number 3 was particularly troubling to the people, as it appears to be a request for the people to get medical records for some person and give those to defendant. I responded that request was unclear, but it appears to be that the people execute a search warrant to obtain medical information for an alleged witness who does not appear to be mentioned in a police report currently in possession of the people. Unless otherwise directed by the court, the people would think that people do not intend to execute a search warrant to seek out private and potentially privileged medical information for this person.
Your Honor, in response to that, I have a FOIA records describing the witness and his shirt that he was wearing, which is the reason why the deputies or the detectives were dispatched to the Puffer Reds parking lot at 3 a.m. that morning. I also have a picture of the witness being right there when I got arrested. I can show you it. It's quickly available here for me to show you, but he's really within.
I really would be
grasp.
The defendant showing anything to the court that he has not disclosed to the people.
So, given that I do have FOIA on my CAD records for the dispatch record of the police when they made comments saying there's a Huron Valley ambulance dispatched for a person due to high intoxicants. I wasn't dispatched through Huron Valley, but this is in my police report. I think this is valid enough to say that he is a part of the same scenery and event.
Do you have a name?
His name is Jacob Spalding. I've known him for 15 years. I was with him throughout the course of the night and
So you want his medical records?
I want to first of all subpoena him to get his witness statement on record officially, and I would also like his records due to the nature of why they.
I'm not going to order. I'm not going to order medical records. If you tailor a request for something that isn't available in another fashion, then that's fine. But I'm going to deny that motion.
Yeah, a lot of my civil procedures I will be correcting and will not have any more problems with. But as for right now,
your civil procedures,
I'm trying to follow the rules of federal civil procedures, and this is my first
federal.
Yeah, this is.
Yeah,
I think so.
Okay, so we're a state court.
Okay,
and this
I'll
is criminal proceedings.
Then thank you for your guidance.
Yeah, so you might want to start there.
Okay.
Okay.
So that 3 is denied.
Huh?
3 is denied, Your Honor.
The whole motion's denied. Yes.
Thank you.
All 3 parts.
Number 4 was to subpoena a witness. I just responded that the defendant should follow the subpoena process that's available to him.
Understood.
Okay. Number 5 was that the defendant is requesting the court produce all audio or video recordings. I said he should go through the discovery process. That's that motion at this point.
It's denied.
Thank you.
Number
6, the people, I'm not exactly sure. There's a motion to seal statements.
I don't know what that meant.
I don't either.
What does that mean?
It means any statements that I made under stress to either the police officers when they were questioning me or before after.
What do you want to do with them?
I would like to suppress them so that they don't hinder my trial experience, as I was not
What does that mean?
well, I was not given proper notice of my rights when I was detained, and I was questioned thoroughly
So you
afterwards.
have to file a motion, you'd have to lay out specifics as to how and or another, any statement that you made, which it doesn't sound to me like was the subject matter of necessarily an custodial interrogation, but it doesn't really matter. You're going to need to lay out all the elements of that before I would rule on that. But in its form, as it sits right now, that motion's denied without prejudice.
Thank you, Your Honor. My response to number 7, which is the defendant is notifying the court of exculpatory video evidence. Okay. I don't have any response to that, really, beyond the fact that it seems that these are videos the defendant has, and that he hasn't received any videos from my office yet, so I don't see how
I have
to
video.
respond to
Sorry.
any piece of this.
I have videos, both FOIA requested from the Ypsilanti Police Department and my own. I was formalizing the process for the prosecutor to build her prosecution.
To do what?
When I requested discovery items that I'm going to do following the rules of civil procedure, that's what I was, yeah.
So this last one, what are you going to do with that? What do you want the court to do?
I want the court to find on what grounds throughout the discovery process that I'm guilty of these crimes.
Okay, sir, it doesn't, you seem to want this process to work a way it doesn't.
Maybe that's a disadvantage of being pro se, Your Honor.
Yes, there are huge disadvantages because I think you know what you're doing, but you don't. It's become readily clear to me. You have no idea what you're doing.
Right.
And so I'm going to ask you, and it's going to cause some difficulty for you. So I'm going to ask you again, do you wish to be represented by an attorney?
I do not.
Okay. Motion denied.
Number 8, defendant requests the court cancel all current bond conditions pending the.
Motion denied.
Thank you. Motion to continue proceedings. People weren't opposed to adjournments, but this is actually kind of includes several things. The request is to continue all scheduled hearings until requested testimony, evidence, and hospital records are provided. So I don't have an issue if the defendant needs more time to be prepared to have hearing, but I do have an issue if he's trying to say that he can't do anything until we subpoena somebody's medical records. So I'm going to get a search warrant for somebody's medical records and depose officers in a criminal case.
Which both of those have been denied. So by default, that would have to be denied if that's what he's asking.
I've made a note of the new address mentioned in section 10, and then there's number 11 is to seal all indictments. I don't know what this means.
I don't know.
All incident related documents and evidence. I don't know what that means.
What does that mean?
It's reiterating the sealing. Anything that I said is really all.
I don't know how that sealing would take place.
Okay.
I think you really need to think about getting an attorney. That part of the motion is also denied.
That's all. Thank you, Aaron.
Okay, so what are we going to do?
Well, I would like a chance to amend the motion.
No. You can file whatever motion you want. But I'm going to tell you something, sir. I'm not going to sit here listening to frivolous motions.
Okay.
I'm just not going to do it.
That's not my intent, Your Honor.
No, I don't care whether it's your intent or not. 3/4, if not 7/8 of that motion that we just dealt with was frivolous. It has no basis in law at all. You're just filing stuff. I'm going to tell you, I'm not putting up with that. Are we clear on that?
We are clear.
So what do you wish to do now? Do you wish to have a preliminary exam set?
Yeah, I'd ask for some for an adjournment in order to review the discovery materials I produced from my FOIA,
That what?
that I've came up with through my FOIA request. Or I'm gonna plan on submitting the procedures as normal through the prosecution too as well, but I need time to review the
What does
documents.
that mean?
That means I just got the documents and I haven't been able to review them, and I need time to review them, Your Honor. I can't act on, decide on something and request for something right now in this moment if I haven't reviewed evidence.
So all you want is an adjournment?
After this response that I submitted to her and she submitted back, yes, sir, Your Honor. Adjournment for pretrial, adjournment for discovery materials.
You know something, sir? Just because you use what seem to be legal words and try to place them into a sentence doesn't mean that it makes sense.
I understand that, Your Honor. I mean,
No, I don't think you do. I think you were just placing words in sentences, thinking that because what you're asking for makes no sense. And if you think it does make sense, then maybe this court needs to send you for a competency. And I'm not saying that jokingly. This doesn't make any sense. I'll grant your adjournment. Next time you'll need to fill out a sheet to do it, but I'm not going to waste the time today to do it because
thank you, Your Honor.
And Your Honor, for the record, I put the email address the defendant should contact for discovery on this post-it note, which I'm going to place here, and he can pick up. He's indicated he doesn't want to communicate with me about this case.
he doesn't want.
Oh, at
He
that
doesn't want to
moment.
communicate with me about his case earlier, so I'm not going to speak with him today about this case. So I've given him the post-it note to get discovery.
Oh yeah, that's a good way to get this going. All right, probable cause conference. Let me at least have some turkey before I have to deal with this again. December 5th. Court is clear, does believe that you do indeed understand the charges as well as the maximum penalties. There are certain dangers in representing yourself, and it can be fraught with some difficulty. However, I would indicate to you that you are absolutely constitutionally entitled to represent yourself if you so choose to do so. I will treat you no better, no worse than a licensed practicing attorney, but that also means that I will not show any favoritism. You are to also understand and know and operate by the Michigan Rules of Evidence and Michigan Rules of Criminal Procedure. If at any time during the course of these proceedings you decide that you wish to be represented by counsel, cannot afford to hire counsel, then the attorney will be provided to you. So that we don't get into a thing, I am going to assume, unless you say something different, that you understood everything that I just said. Hearing nothing different, what are we doing? Sir, do you wish to be represented by counsel? I guess I'll ask that.
I do not.
All right,
Thank you, Your Honor.
what are we doing?
I think defendant has a pending motion.
Yes, go ahead with your motion, sir.
Still waiting, motion to compel the officers. I thought I'd be here today to speak with them on the record. It's what I've been requesting since my arraignment.
I know, but you requested a deposition. That wasn't going to happen. So what is it you're looking for the court to do?
Your Honor, I'd like to speak with the officers on the record. I've been requesting this since I'd like to.
So do you want to have your preliminary examination? Is that what you want to have?
Yes, Your Honor.
All right.
Sorry.
Is there a response from the people regarding that?
Your Honor, that is one part of the motion.
I know.
And so as to that part, people will be requesting an adjournment of the preliminary examination today as the officers are not here. But as to the other pieces of this, there are many more things. I did file a written response, which I'm happy to rely on, unless the court has specific inquiries placed to make that is not sufficiently flushed out.
All right. Sir, what about the other part to your motion?
Is that in regards to waiving my bond conditions? Which part are you referencing, sir?
It's your motion. You go ahead. I will rule on that part. What other part of your motion do you want the court to deal with?
To waive all bond conditions, leaving the state, and I'd like to get the officers on record. That's really what I've been wanting to do. I thought that's what I was here today. I was prepared to do, Your Honor.
Do you have all of the discovery?
I was just submitted an audio file this morning, Your Honor, from the prosecutor. However, it must be corrupt or something. It's not going through. I'm trying to get a valid copy from her. But other than that, I believe I do.
That's correct, Your Honor. We did send over an audio file this morning, and I did see the defendant reply that he was having trouble playing it on both his laptop and on his phone. I will note, I'm just seeing today, it looks like the defendant may have a MacBook, and I know that those can have a little bit more of a difficult time with some of the audio files that come from my office, so that may be something that, I don't know that the file is corrupt. I think there's just an issue playing the audio.
Got it. And this is a audio of?
I believe it's the 911 call that brought the officers to the scene, but it would not be an exhibit that people plan on playing at the preliminary examination.
All right.
I would like then to motion for a preliminary examination to get the officers in here on the record, then, Your Honor, please.
All right. Is there anything else you needed the court to deal with? You mentioned bond conditions. You say you have all of the discovery. There may be an issue with the playing of this one audio. Is that correct?
That's correct.
Anything else you're requesting?
No, Your Honor.
All right.
At this time.
With reference to the bond conditions, all of the bond conditions are standard bond conditions issued in every case. So the defendant's motion to change his bond or the conditions of his bond is denied. The court does deem them appropriate and properly set by the magistrate. Does not see an abuse of discretion regarding that. With reference to the court doesn't have to deal with any of the discoveries. We have it with reference to the preliminary examination. I'm more than happy to give a preliminary examination date. I will grant the people's request to adjourn in this matter and would set it for the 21st, if that will work with everyone's schedule.
January 21st?
Yes.
That's fine for the people.
Fine for the, Your Honor.
Yes. So preliminary examination will be set January 21st, 2025, 9 a.m. before me. That's in person. Defendant's bond with conditions is continued.